38A to the government employees employed at the school. So to continue, I am going to just do an introduction and saying to you, we will supply the slides to you in Afrikaans and English after this, and to all our member schools. We will send that to you. And then during the presentation, should you have questions, we will deal with it. If you put it in the chat function, we will try and answer it immediately. And furthermore, we can deal with those questions at the end of the presentation if there's time available. If not, we will answer them via email to the specific people asking the questions. But I hope you enjoy it. I hope you learn. And to start off with it, we're going to start discussing Section 38A of the South African Schools Act as amended by stating what is the purpose of Section 38A. 38A is due to the pressure that came onto schools where the government only supplied a certain amount of teachers and the school's need was there due to the curriculum expansion and to other operational requirements that schools had more work than could have been done by only the people supplied by the government. And then what happened is SGB staff were appointed, but then in history, the government employees then came back, the educators and PS staff, and said, but we want to do extra work. And then rather of appointing somebody, why don't you just remunerate us? And that was how Section 38 was, the amendment was brought about by saying that a governing body may apply to the employer, the Department of Education, to remunerate these people, to pay them something for over and above additional work done. So firstly, that you've got to keep in mind, there's a job description for all people employed at schools by the department. PS staff has got that, educators, heads of departments, deputies, and principals. So the first thing, that the fulfillment of your job description, that is what you're getting paid for by the government. So should we, as a governing body, consider paying you more, then we will have to compare your current job description with the prescribed job description. And only if you do more than what is stated on your governmental job description, then the HGB can start considering of paying people more. And these payments can be in the form of remuneration, financial benefits, or benefits in kind. So it can be money. Financial benefit would be a credit card, a petrol card from the school. That is a financial benefit. And a benefit in kind is, historically, there was a big matter regarding the school paying the SMT people, the gardening services, cleaning the gardens at home. So that would be a benefit in kind. So if you want to do any of that in paying any of your people additional fund among those people employed by the government, you have to apply to the government to do that. And then that application must be done 4 months before your budget is finalized. And usually we talk about 31st of May or 30 June, that it must be submitted, your applications to pay individuals more, a form must be completed, and that must then be sent into the employer to do a evaluation and determine if it's possible or not possible. We will discuss the application form a little bit later and give you certain indications on that, what is there. What is also important, you cannot use government money. The allocation received from the government in May and November every year, that may not be used to pay additional remuneration to government employees. So the SGB must take note thereof that they will have to declare what resources and what process are they going to use to collect money to be enabling themselves to pay Section 38 to people. So in a nutshell, that is Section 38A, and we're going to explain much more to that. To whom is Section 38 applicable to? To all governmental employees and not to SGB employees. And then what schools tend to neglect sometimes, it's not only for CE staff, but it's also applicable to PS staff. employed by the education department. We often find schools that only apply for educators, but they, however, do extra payments to the PS staff, the general assistants, when they act on a Saturday after sport or in evenings when the hall has, the chairs has to be packed. We have to know that we have to apply for them also, because they are government employees, and the one group is employed by the Employment of Educators Act, and the other group is employed in terms of the Government Employment Act for government employees. So you cannot, and it's a Public Service Act, you cannot just pay them. It would be contravention of the Act. In short, what should we have in place for Section 38A? Firstly, the application, as I stated, at least 4 months before the budget is finalized. Before the 31st of August, the department has to give back approval of the application, or they can turn it down. They can turn it down. If the SGB is serious, then after not being approved, they have the right to appeal to the MEC, because the employer cannot, without a good and valid reason, not approve the request to pay people 38A. Then thereafter, after it's been approved, then it must be included in the budget for the school. And it must be presented at the AGM for parent approval. We don't have to indicate what the individuals earn there, that what we're going to pay, but we have to stipulate a specific amount that parents approve, number one, as a resolution, and secondly, that they are prepared to pay Section 38A as a second resolution. If all of that is in place, then it is a requirement that there must be a contract, because this is a second employment, and we have to have contractual obligations towards each other as employer and SGB. And that's where a contract is needed, and also to safeguard yourself, and also as a prerequisite of the Basic Conditions of Employment Act, you have to have a written explanation, a job description of what you should be doing. And that's to indicate what is your over and above tasks that you have to perform. And Section 38 then only becomes payable after this work described in the job description was actually done, and the funds are available for that. And then we must take note of that every year is a new application in terms of Section 38A, because the law stipulates it's not a permanent agreement. This you have to apply every year and annually, and we will expand a little bit on that. But just coming back to the additional work must be done. The question currently that we bump into is COVID. We budgeted, we got approval, we've got contracts, and the people had to coach sport, hockey, netball, rugby, and do extra hours of Saturday games, and they've got to drive the bus and do first aid and all of that. So if all of that work was done, you should have been paying those people if the money was available at the school. However, due to COVID, those activities did not take place. And because then certain SGB said we cannot pay that, and that's actually correct because the work is not done. I can only pay you if the duties is performed, right? So this created a lot of conflict at various schools. Some schools opted to pay a 25% or a 30% or 35% to keep this in mind because the people were expecting this. But remember, they couldn't perform these duties. But in fact, if the work is not done, you cannot demand to be paid for that. We will, however, get to the application form later and attend to Part C. That is a different ball game that you have to take into consideration if you bump into problems like these. The Section 38 application form, then specifically if we deal with that, must be completed as previously stated for GDE educators, CS staff, and non-educators PS staff, because you must obtain permission from the employer, from a GDE, to perform any work outside their normal duties. The employer would, however, then consider, is this supporting the core activities of the school? will this not hinder the person to perform his normal duties, what he's paid for by? And furthermore, what will the influence of this be on the contract of employment in terms of legal requirements? So the employer will look at that specifically in the evaluation of this form. Should you complete the form, the SGB, on advice of the principal, obviously, and all the sport coordinators and other people of the SMT, will complete the form, and the form consists of Part A, Part B, and Part C. But Part A will be the extra hours worked by the educator or the non-educator, meaning after your normal working day, and remember, CS staff is appointed for 1,800 hours per year, and then that boils down to more or less 200 school days. This year, 193 school days, but it works more or less to 9 hours a day. So the educator will have to perform duties more than 9 hours, while the PS staff is appointed for 40 hours a week, excluding lunch times. So only when they work more than that 40 hours, then we should consider this, that they are liable. And then we will complete form, the Part A of the form, and stipulate the prediction of, we are estimating how many extra hours will be worked to fulfill the job description and the additional duties that this person then has. So we have to do that. However, there's also, and we bumped into this, that you cannot just go crazy with the hours there, because the legislation says you cannot let an employee work more than 45 hours a week plus 10 hours overtime. So the maximum hours a person can work is 55 hours in a week. And often we find out, if we look at the hours that the people book there, it's impossible, because they book like 2,000 hours and there's 200 school days, boiling down that you're working 10 hours overtime on a daily basis. The department cannot agree to that, because they will be contravening other legal requirement in terms of the Basic Conditions of Employment Act. So we will have to calculate the hours there correctly, and I know that's an estimation, because we are actually in June this year, already looking at next year. We don't know if there's going to be an under 13C hockey team or an under 13C rugby team, but the fact is we have to calculate and do the application. So should the team be there, then we can remunerate this person. So my advice is, yes, we do the application as we are predicting what will be in place. And should it not happen, remember, the fact that we applied for it, it's not a force to pay that. You cannot then be forced, because the services must be rendered. So that's regarding Part A. Part B is more regarding the extracurriculum and community service. So this is more the academic side, where we are budgeting for the people doing extra classes. I know at a lot of schools, it's compulsory for an hour a week that you've got to stay after school and be available for extra classes. So that's over and above, it might be added to that. So yes, and that's a 1 hour a week. But also then, if you look at section 38, the completion of form, it says, but there's a compulsory 80 hours that an educator must perform of community service and extracurricular. So the first 80 hours is basically free, and only thereafter you can start calculating how will you remunerate the person. After we've done that, then we move on to Part C. Now, Part C is the part of the form that if I want to do additional remuneration, I can pay the person for his management skills, his experience, the fact that he's making a big contribution to the school, and that he's got certain very scarce subject skills or certain employment skills that makes him a very valuable person for the school. And on operational side, he's playing a very, very big role in keeping the school at a very high operational level. So at C, we don't calculate according to hours, but we'll have to put a price on the value that the person brings to the school. We will have to do that. So on C, actually top management of the schools are actually, the majority of them you apply for C. Why? Because the school is built for 600, but there's 1,000 learners. Furthermore, the department appoint 40 educators that the principal has got to overview, but the HEB goes and they appoint another 20. The budget, if there were only 600 children, would have been 6 million, but now there's 1,000 children, now is the budget 10 million. So the responsibility of the principal and the whole management staff gets more and more and more, not by the decision of the employer, but by the decision of the SGB. Therefore, the SGB can, if possible, then start applying for 38A. But you will find schools that are not able to do that because the funds don't allow it. And I can't think that there would be more than 10% of the functional schools and 10% of the 24,000 schools in South Africa that are actually paying Section 38A payments. So it's a very small group of schools that is in this privileged position of being able to do that. But however, these days, if you advertise a position for a person in a management position at a school, or you want you advertise and get a very skillful person, the question is asked already at interview. What is your Section 38A payments? And you have to then inform the person if you do it or you don't do it, and motivate. We can't do it because we are not a school that's got enough money for that we cannot do that. So that's the form, and the form must be completed for every individual person. So you actually apply for every individual employee to be remunerated. The completion of the form must be specific, must be very specific. And if you've got all the forms together, you must send it with the budget approval by parents to pay Section 38 and the amount, and then also a motivation of where will these funds come from. Did the parents agree to pay additional school fees? It's fine. Are we going to do fundraising? Are we going to get sponsorships for this? You can include that as a motivation for the employer to make an overall evaluation of saying this is a feasible situation or not a feasible. Just to recap, usually the timeline, applications must then be submitted between 31 May and 30 June. By 31 August, the HOD will either approve or reject, and they usually do that on district level. If it is rejected and not approved, the SGB has the right to appeal before 30 September to the MEC. And then if it's not needed to appeal, it's been approved everywhere, it will be included in the October-November budget, and only then, if the money is available, it can be implemented from the 1st of January. Furthermore, if this process is not followed correctly, and it's a pity that we do often find schools that pay 38A but don't follow the rules of the game, it states clearly, Section 38 says, the SGB can be held responsible in person for unauthorized payments made. They will have to repay the payments back to the school, the same amount that's been unauthorized paid out. Then we'll come back to those individuals who authorized that payment, and they will have to pay it back to the school. And the employee who accepted this additional remuneration without approval from the education department is also guilty of a misconduct. So we strongly advise the schools, if you intend doing 38A payments, file the application, get approval for that, appeal if it's not approved, but only start doing the payments after you've received the okay from the employer to be able to do that. What needs to be in place before it can be paid? Approval from the provincial department on that form, a contract of employment, and we will come to that contract because that contract has got different determinations. Leave is, for instance, not applicable to that. The contract also has to have a form of dispute resolution as a grievance or disciplinary procedure attached to that, because remember, you have now appointed this person, you've got a contract with him, and should things go wrong, the remedy should be available there. we have to have a job description, specifically what are your duties, and also in the job description most probably include the time frame, because you've got winter sport, you've got summer sport, certain cultural activities are only in a certain time span of the year, so that the person knows that he is employed for that 3 or 4 months while doing that. And this sometimes creates a problem because you win your league and you continue and win your league and your circuit, and then you go on to provincial level, international level, and we cannot always determine that. So we will say in the contract, but if you continue and you win and you continue winning, that yes, this contract will be extended up to when you've played up to or participated to that level where you finally have to withdraw because you lost there. Right. Important is that these people from the government employees that's receiving 38A must be loaded on your official payroll as the other SGB staff is loaded onto. They must pay UIF and they must pay as you earn. There's no ways, because it's additional information. If we don't deduct, for instance, pay as you earn, that individual is going to be very angry because we will have to pay income tax in at the end of the year, because the receiver of revenue will pick up the payment that was made to him, and the fact that his income is then increased and pay as you earn were not deducted, it will end up and you'll have to pay more. This is currently a problem that we're experiencing with grade R practitioners, where they receive a stipend from the government and a SGB component, and then because it's too low salaries, but in fact the pay as you earn that had to be deducted if they were added together must have been higher, and that's why grade R practitioners end up paying it in. Furthermore, the work must actually be completed, must be done before you can pay this person. So that leads to that we will have to evaluate, and supervisors in the school will have to look at different things. Were the people at the practice, did they do what they should have been done? Did they complete the attendance register? Because that's an important part of it. And then the last point, before it can be paid, funds must be available. If you complete the form A, B, and C, right at the bottom, it says to you, this is not an expectation. It is not the force majeure that you can say it must be paid. You must accept that schools are in a very fluent position, that they cannot maybe get all their school fees in. They don't, a sponsor just disappeared. The money may not be there. So what then is they cannot pay that, and you cannot demand the payment from them. However, there is a contract and all of that, it's based on the expectation that school fees must be paid. And only then you can be requesting, and then the school is liable to pay you those specific amounts. The register, when you then do these additional work, time will have to be, your time from starting and knocking off, doing your extra duties, if it's linked to hours, there's no ways that you can get around it. There must be a register or a record in some other form for that specifically. Right. Now, this is a very difficult one because you're coaching on a hockey field a kilometer away from the admin building. That's why we need a supervisor there to confirm that this person actually pitched up, he was there, so that we can come back and then complete the form or the claim form or the register that they were there. The record keeping must be done in a register, as per example, supplied to you by the Provincial Department of Education. And this register is also subject to an annual financial audit. So the department can come and they can request this register to confirm that, yeah, you applied and these people are working these hours, but just show to us that they are working these hours before you pay them. And also at the end of the year, there must be an annual financial audit saying that these people did perform these duties. And that is only a very healthy position for the SGB to be in, and to be able to prove that they're acting responsible with the monies of the school and the parents that are paying. Essentials of the Section 38A contract, leave does not apply, because so you cannot take leave from those obligations that you have to fulfill there. And now the question comes, you in sick leave, but you cannot perform, you cannot do your coaching for whatever you're appointed to, you cannot perform your administrative additional duties that you were appointed for. Now you're on sick leave. I believe for sick leave, it's a valid sick certificate. Yes, the person will have to be paid and somebody else will have to do the job of that person. And the question comes up, can that person then claim additional payment? I believe if there was not an application filed for that person, then you can't do it. However, if there's an application and the schools I know apply for, they're going to pay out 40, but they apply for 60 to make provision for things like these happening. The working hours should fall outside the normal working hours because the government pays you those certain hours that you're working there. So these additional hours worked must fall outside that. Now, this is also a question mark, I know, because now the educator is coaching from 2 to 4, then go home and then at 4 o'clock start marking books to 6 o'clock. So we will have to bear in mind and we'll have to be flexible regarding that we'll have to calculate hours to that. As mentioned previously, there must be a disciplinary procedure and a grievance procedure attached to the contract. Should these contracts be terminated, a fair process must be followed because that's the rule of the game. But it's not necessary to apply Section 189, the retrenchment. So if these contracts are ended, it is not that there is a Section 189 applicable here. We have to, however, follow a fair procedure in terms as described in your contract, in your disciplinary code, how to then terminate these contracts of these people. So it's important to do that. We regularly pitch up at the CCMA because disputes are lodged because of contracts of Section 38 appointees that were cancelled, but there were no fair procedure followed. So that creates a problem because can these matters be taken to the CCMA? Yes, it can. And we do that. So rather follow the rules that we supply to you. And in that sense, we make sure that you have a valuable case should we go to the CCMA. However, the Section 38 stipulates to you, all right, and in Section 5 of 38A, it says, subsistence and travel. SGBs do not need to apply in terms of Section 38A for subsistence travel payments. So if the person travels or live out for a day or night, and you want to remunerate them for that, as done as on sport tours on a regular basis, then you don't have to apply for that. You don't have to apply for that as long as the amount that you're paying these people are not more than it would be payable to a public servant, right? That's not employed by the SGB in the public service. So annually, the Public Services Bargaining Council reviews these amounts, and you must make yourself aware of these amounts. What is a daily tariff? What is a tariff for staying out per night? What is the kilometers that can be claimed for you? And you cannot pay that person more than that. Because if you pay more than that, then it becomes a taxable benefit, because then it's additional remuneration. But you don't have to apply for Section 38A to pay this to government employees in subsistence and travel repayments. The school must keep full records of all such payments made to state employees. These records must include the annual audited financial statement of the school. It must be available for any person to come if you get a dispute and say, yeah, but you paid more for subsistence travel than what you might have done, so that we can have the records available and that we can set the picture straight and try and settle the dispute. So that's very important to take note of that. What are the common problems that we experience regarding Section 38A? And I'm going to go to more practical examples here. Right. We must remember that Section 38 needs an annual approval, and it's only valid for 1 year. What happens is educators and PS staff gets appointed, and then they take the Section 38A contract, they add it to their current employment payslip, and they hand in that to the bank to do loans or credit applications or buy cars. The fact of the matter is you are actually doing something that you should not be doing, because should you the next year you lose Section 38A because you cannot perform the duties, or the duties are not required by the school anymore, or somebody is permanently appointed to do those duties, then you're going to end up with problems that you cannot repayment the credit that you made, and you cannot repay the loans. Then you're going to end up in turmoil with that specifically. So people, don't use this and see it as a permanent allocation that you can get. And to get to the real practical world here, I have mentioned, I'll come back to part C later. Part C, your scarcity, your management experience, your value added to the school, that it's not negotiable. You're a serious role player in the success of the school. They do budget on C. And there, out of legal viewpoint, it can be established that you are actually getting an expectation. So the work should not, if you're not able to do the work as scheduled in A and B, but C, you're still available to the school, it creates the expectation that you can still demand the payment for C. So that is out of the legal viewpoint. Part C must be approached very, very carefully, because it can create the expectation by the employee, and that part C, then most probably, yeah, because that will, if your position at the school don't change, most probably will be carried over year to year, but still it's not a guarantee, because the school has to have the money to do so. And that leads me to my second point, where SGBs go and then they do headhunting and they appoint people, and then they promise Section 38 payments for the rest of the career of that person. That SGB doing that promise cannot do that. The reason being for that is we must annually budget for that. And if we don't have the money, we cannot fulfill that obligation. And the problem with that we're experiencing in schools is that it's carried over from one generation SGB to the third, the second, the third, the fourth, and the school situation suddenly changes then, right? And when it changes then specifically, then we can't anymore do these payments. And that creates a problem then. And then you've headhunted me. I've applied for 10 positions and all of them were great. I came to you because of Section 38. I should have taken the other 9. It's a difficult, and it leads to conflict situation. So SGBs must be very cautious of not making such a promise to people. Grade R and SGB staff cannot earn Section 38A. The reason being for that is grade R practitioners and SGB staff is employed by the SGB, and you can pay the SGB whatever you want in the form of agreement, a contract. You can pay them for additional work, but you don't need the government's permission to do that. I've explained to you that other problems not adhering to the maximum permissible hours per week in the application. So you cannot work more than 55 hours a week. And we've got to look at Section A of the form specifically. If we add those hours up, it's hair-raising to see the hours that the people say they're working. And I'm not saying educators is not working hard and working long hours, but we are binded by law to 55 hours. If you work more than that, you cannot claim more than 55 because the department will not approve that. They will not. Then we often get schools are giving cell phones to employees to perform their duties because they are there after hours and they've got to be available. It might be support staff, the school psychologist, it might be educator coaching, and at night time when the parents want to may be able to call him and he must be able to call parents. If a cell phone is supplied to you specifically to perform your duties as an educator or peer staff member, and you're using that cell phone only for work and not for personal benefits, then that phone is not included in Section 38A. You don't have to apply for that because that is in fact not a benefit. It's part of a working tool. So then you don't have to apply for that. What about general assistants? We often get general assistants being paid Saturdays and evenings and Sundays after the church rented the school hall, and then they get paid 150 and 150 and 200 rand, but there was never any application made for them specifically to the employer. That cannot be done. That cannot be done. We have to also file applications for general assistants employed by the Department of Education. The next problem we get is that employees do get their Section 38 and everything is going well and the school is fine, it's running perfect, money is available and everything is there. And for 3 or 4 or 5 years it's going on, and it was possible to do an increase now and then on the Section 38 payments. But, however, it cannot be annually expectation that Section 38As will increase every year. It cannot be expectation. Why not? Because the SGB must first determine what is the income going to be, the budget approval, all of that. And if parents are suffering, we cannot expect Section 38 to get a percentage increase. It would be totally unfair to do that. For instance, in the current situation where we are with COVID, I don't think Section 38 can be increased. It should not be increased because the whole economy is saying to you it cannot be done. The next point is staff leaving and no application for replacement. We often get a head of department, we apply for him, and he gets a promotional position as a deputy at a new school, but he had to perform certain duties and we applied for him. But now he's not there anymore. So we cannot pay him, but somebody else has got to take over his duties. And that's where we say we have to make provision by applying for hours, but maybe apply as if this person would be a league winner or that you would work extra hours so that we can accommodate something that happened, a vacancy that started off like that, so that we can get somebody in his place and still appoint that person to do the duties. So yes, I know people might differ from me, but I would rather over budget a little bit and make it possible, because I don't have to pay that, I don't have to spend it, but if needed, so that I can pay that person. Regarding Section 38A, the quality of work performance are sometimes not up to standard. So we're not happy with what this person is performing, like the duties that he's doing. He's not doing what he committed himself to. So if we look at that specifically, part of your job description will have to be that you have to need a performance appraisal, not maybe as formal as the IQMS, but at least have a description of what level are you expecting of this person. For instance, sport coaching, how should the person be dressed? When should he be there? How long before the time? What should he do? What should he not do? During games, how should he behave next to the field? Shouting at the ref, that's thing that's common happening, and I think that's a little black spot behind our sport culture at this stage. So we can describe a code of conduct and a level of expectation of standard to what we do. What about performance bonuses and performance evaluation? That's totally, it's against the law. I cannot pay performance bonuses and performance evaluation. I would rather suggest to you, you budget for this person to such an extent that he's going to become the league winner. He's going to do much more than what he was. He's going to work extra hours, even more hours than what you anticipated, and you budget for that. And then you pay him for the actual work or the actual performance reached by winning the Blue Bull Circle or becoming a national champion with his team, or the coaching of the netball achieve some high standard of recognition. Then we do that because then we budgeted for the extra hours, and the extra hours will actually be a performance bonus, but we cannot budget for a performance bonus. That is not acceptable. We cannot do that. Before I go into the questions, because we did receive some questions, I just want to say the other prickly pear coming up at schools is where educators pay lesser school fees, or they don't pay school fees at all. They don't pay school fees at all. Now, they also don't get exemption, and they don't apply for exemption of school fees. So by granting them this percentage that they don't have to pay is actually against the South African Schools Act, because exemption could actually only be granted to people who applied for specific exemption. And furthermore, I know in the Act it says, there's a paragraph saying that the SGB can, on the merits of the case, evaluate. But I think that's more applicable where a person comes in and says, here is a contract for you. I will get my money in October and I will pay you. And I say, I sign a acknowledgement of debt to you guys and I will pay you. I think that's applicable to that paragraph. But I don't think the SGB has got a free hand of deciding that you're due to that. I think the correct way of handling this, and I know I'm going to make certain people angry, but however, with the new tax rules is, remember, if I give you a benefit, it is taxable. So what I would do, I would go to paragraph C. If I feel and I believe that every educator is very valuable to a school, then I will apply for an amount equal to the school fees of that year with part C of the application form of Section 38, because I value every educator and I would like to give them the benefit, and I would like to give the benefit to them due to the fact that they're very, very valuable to my school and they are contributing immensely to my school. So what I will do then is I will apply, and it will be an in and an out in your bookkeeping system, paying this over to the person, but the person actually paying it back also. But one thing you won't avoid then is the tax on that specific benefit. If the person has got other Section 38A applications, what you're applying for, you can add the school fees onto that. And I would recommend SGBs to look at that, as every educator is very valuable. So we as SGB, we say we are going to apply for Section 38A in the format that's just explained. And if we get approval for that, yes, we can pay them, but we can never get around the tax deduction on that. Right. The GDE requested, this is a question, the GDE requested us last year to include grad R in the application. I have taken that up with the department, and I know there was communication out, but if you look at the regulations and you look at the 2019 transformational guidelines applicable to grade R's, it says to you that the contract of employment is with the SGB. Department pays the stipend on behalf of the SGB, and there's no chance. And I have also clarified that with senior officials in the department. Section 38A is not applicable to grade R's because they are not employed by the government. The stipend is paid on behalf of that. And I refer you to the regulations of grade R and the 2019 transformational guidelines, specifying specifically what I'm saying there, that you don't need to apply for them because they are not government employees. Then secondly, if you applied for your current deputy, but she got promoted and will be replaced by a new deputy, can you automatically transfer the application to the new deputy? No, you cannot do that. But however, a lot of schools, we've advised them to do a late application to the district office, meaning that this is the situation that happened. We have budgeted for it. It is available in the budget. The resources or sources for collection has been identified. So all of that is in place. And I say to you, then you do the application. And I don't think that application can be just rejected by the district office because there's merits on the case. And if that's rejected, we can take it on appeal to the MEC for this specific matter. We can do that. We can do that. Lastly, I think Section 38A is a contributor to the functionality and performance of high-performing schools. And I think Section 38 is there to stay. However, we should be very cautious that Section 38A, and I know the new amendments to the South African Schools Act proposes that Section 38A payments may not be more than 20% of the annual salary of the government employee. I think that's a very valuable guideline, because if we start competing schools, different schools are competing on Section 38A, this gets out of hand, and I don't know where it's going to end. So we have to set ourselves a limit and say, if the South African Schools Act are going to be an amendment to that, that we must take note that you cannot pay more than 20% of the annual salary of such an employee in terms of Section 38A benefits. But I believe 38A is a valuable contributor to keep people, to get people to apply for positions at your school and to make your school super functional. So I say there's a value in this. And we have to look at that specifically then for those 5 or 10% schools that are able to do that. And we must continue with it. And I'm positive about the future of that. That ends today's session. I know it's a little bit short of an hour, but I hope you've learned something, and I hope you've enjoyed the path with me. And should there be any further questions anymore, feel welcome and send them through to us. You have our email address there, and send it to us and we will answer that. We will send the presentation to you in Afrikaans and English to our member schools. And should you want to, there will also be a YouTube video recently in future, most probably in the next week or two, be posted, so that you can also use this for further spread if whoever wants to attend to that. Thank you very much.